I would like today to, in some senses, merely to elaborate on many of the points that were raised in the presentations last night. Almost everything that I'm going to say, in one way or another, had been touched upon by our speakers who framed today's sessions so well for us. And in sort of overview, I'm going to try to make sort of the following 3 or 4 points about Pacem and Terris. First of all, that Pacem and Terris can be seen and situated within a trajectory of the Catholic Church's, the development of the Catholic Church's use of the language of human rights. And that trajectory can be seen in relationship to a separate trajectory of the development of the language and concept and politics of human rights in mainstream secular human rights discourse. And that when we map each of them in this way distinctly from one another, we see interesting convergences between them over time, certainly not an identity of them, not an assimilation of one to the other, but at best an approximation. Secondly, that in some ways Pacem and Terris represents within those trajectories the apex of that convergence, conceptually at least. In political practice, perhaps not. That came later in the Church's engagement with the politics of human rights, as my colleague here, Dan Philpott, is much more able to describe to us and has done in his work. And finally, that when we read Pacem and Terris today as opposed to 50 years ago, it challenges us less by revealing the convergences of Catholic and secular modes of discourse and thinking and speaking about human rights, as it may have and presumably did do 50 years ago. And perhaps today more it's striking by bearing witness to some of the fundamental differences between these two bodies of thinking and speaking. So, when we reread Pacem and Terris in the context of Catholic social thought generally, even after many previous readings of the document, I think one can't help but be struck yet again by how pervasively the document is, from start to finish, about rights, about human rights. As we heard wonderfully and clearly in yesterday's presentations, it's a document that above all is about order, and order in many different levels, bringing an order to human affairs that reflects the divine order of the universe. It's also, again, as we heard yesterday, a deeply personalist and humanist document that consistently places the dignity of the human person at the center of all political and social order. As the document says, any well-regulated and productive association of men in society demands the acceptance of one fundamental principle, that each individual man is truly a person. So order and human dignity come together in Pacem and Terris in the idea of human rights. Rights are the very first point that is raised in the document and treated extensively, disproportionately to the other points that are raised later. They're present throughout, and the document closes with a reference to human rights. So there is no question that rights talk here is more pervasive than ever before in any magisterial document of the Church, and presented also more authoritatively in form in being in a major encyclical than, for example, a Christmas address on the radio than ever before. Now, does that pervasiveness in fact represent a fundamental change, a rupture, a discontinuity with what came before it? I think not. It may be a difference in degree, but not fundamentally a difference in kind, especially when we read the document, as Archbishop Minerath urged us to do yesterday, through the lens of a hermeneutic of continuity. The expansive incorporation of human rights is, of course, startling in a certain way, especially if one focuses narrowly on the troubled relationship of the Catholic Church to a certain strand of anti-clerical European Enlightened liberalism, especially in the 19th century. Or if one focuses on a supposed deep philosophical contradiction between the language of objective natural law, or jus, and subjective natural rights. But if instead we see the document and read its pervasive interest in rights with a broader vision, it is in fact part of a long and sophisticated engagement and development of Catholic thinking about rights that began in the Middle Ages, found a clear articulation in the encounter of Europe and Christianity with the New World in the 16th century, that underwent a certain dialectic with secular liberalism throughout the 19th century, and that culminated in the social teachings of Leo XIII, Pius XI, Pius XII. It's a continuity that, in particular, as Marianne Glendon has shown, as I've tried to echo, can be seen in a distinctively important way, especially in the history of Latin America. And that's one of the reasons why we're so fortunate to have José Salaquet here engaged in this discussion as well. And it is also a narrative that is closely related to the political practices of Catholics in the world, and not merely an abstract intellectual discourse. Catholics engaged in the social movements in Mexico at the turn of the 20th century, for example, who contributed to the development of that social rights of that constitution. The Catholics who were engaged in the first Christian democratic political parties in Europe, who drafted the Irish Constitution of 1937, the first constitutional document ever to invoke a protection of human dignity as such. Evident in the vital contributions the Catholic intellectuals and activists made to the development of the Universal Declaration of Human Rights in 1948. Now, my point here is not to reconstruct all of that history, but merely to suggest that it should be abundantly clear to us by now, given everything that we know about the history, that Pacem in Terris' emphasis on rights is best understood within a narrative of a Catholic development of natural rights and human rights thinking over the course of at least 4 centuries. Now, that's not to say that the understanding of human rights that it represents is not also influenced in very important ways by the dialogue with and relationship with the idea and practice of rights in secular liberalism. On the contrary, there's clearly a reciprocal exchange going on between them, one which Benedict XVI articulated very explicitly in acknowledging what the Church has learned and acquired through its engagement of the challenge of the Enlightenment. But if we reduce the story to that merely of a Catholic accommodation or assimilation of Enlightenment thinking, then it becomes impossible to see Pacem in Terris in its entirety and in its complexity as a document that represents both an appreciation of and a valuing of a common human rights discourse, but also a document that squarely presents crucial and central differences between the Catholic social tradition and secular human rights concepts and practices. It would also, by the way, although this is not really the main thrust of my discussion, a reductive approach like that would lose sight of the way in which the conventional global discourse of human rights in the secular world has been influenced by Catholic ideas and practices over time, but that's a story for a different day. So let's take a look then a little more carefully at both the points of convergence and the points of difference or divergence between the vision of Pacem in Terris and conventional secular discourse on human rights in the world, beyond merely the generic emphasis on human rights as such. There are certain clear common points, starting with the foundational idea of human dignity. The dignity of the human person is present in every human rights document that has ever been drafted and adopted internationally, starting with the Universal Declaration of Human Rights. Now, it's a dignity that is said to be inherent in the human person, and therefore clearly precedes positive law and the authority of the state. But beyond that, as Archbishop Minerath highlighted for us, within the human rights world, that dignity is otherwise ungrounded. it is, therefore, there's a certain difference too, which I will come back to. But the starting point is human dignity as it is in Pacem and Terris. Secondly, on the basis of that starting point, the particular rights that are then specified and articulated as necessary for the realization and protection and recognition of human dignity are remarkably similar to the documents, at least as they existed in 1963. The right to life, the right to bodily integrity, the means necessary for the proper development of life, including food, clothing, shelter, medical care, rest, social services. The right to a good name, not one so often recognized today, but that matches in particular the Latin American documents on rights. The freedom to investigate the truth, especially through freedom of speech and publication, as well as the right to be accurately informed about public events, a framing of the right to expression information that was, in some senses, ahead of its time. Pacem and Terris lists the right to education, the right to worship and profess religion, both public and private spheres, and very significantly, the right to found a family and the equality of rights and duties of both the man and the woman in the family, the protection of the family as a fundamental unit of society, and the recognition of the primary role of parents in the education of children. As I'll mention later, it's not often realized today how central all that collection of rights were to the earlier human rights documents. Today, they're quite seriously under attack, as I'll come back to at the end. Pacem and Terris recognizes a variety of labor rights, the right to private property, subject, of course, to certain social responsibilities and obligations, the right of association, assembly, movement, political participation, even the right to a remedy, to the legal protection of these rights. All these things correlate very closely with what we find in the formal documents of international human rights law of the time, and as well as today. There's also a commonality in what is absent, those rights that are not included. But the third point of similarity is the recognition of a need for a public authority, institutions and laws to safeguard all these rights, both within states and between states, among them. There is an explicit endorsement of constitutional democracy as, at least implicitly, a preferred mode of doing so, which was quite an important thing, an important step. We're engaged in a narrative not only of the development of the endorsement of human rights, but of democracy as a mode of governance as well. Fourth, and finally, there is in common between Pacem and Terris and mainstream human rights discourse of the time a recognition of the relationship between legitimate political authority and the protection of rights. As Pacem and Terris puts it, the attainment of the common good is the purpose of public authority. The common good is best safeguarded when personal rights are guaranteed, and therefore, and I quote, "the chief concern of civil authorities must therefore be to ensure that these rights are recognized, respected, coordinated, defended, and promoted." So implicit in that, in Pacem and Terris, is a huge challenge, especially for a public international lawyer, to classical notions of state sovereignty in the international sphere. Is something that was present in and common to Catholic thought about sovereignty throughout the historical epoch of the modern state, but that human rights principles have come today to represent within international law generally. So we see international law again converging with Catholic thinking on these things in Pacem and Terris. All those really represent a very substantial commonality. And yet, let's not lose sight of the differences as well. There are a number that go back to my earlier reference to the absence of a foundation for the dignity that is invoked in the human rights sphere. In the Universal Declaration of Human Rights and in subsequent instruments that are based on dignity, but also, as is well known, they're based on a deliberate methodological abstention from expressing any substantive understanding of what that dignity means or where it comes from. In Pacem and Terris, dignity is said to be inscribed in man's nature by the Creator, the Father of the universe. Quote, "He," meaning man, "is a nature endowed with intelligence and free will and has a destiny that is eternal." So there is a strong emphasis in this idea of dignity on the unity of the spiritual and material dimensions of the human person, and a strong emphasis on the reliance on natural law to determine what the requirements of dignity therefore are. All of that is absent in the Universal Declaration and other instruments. Secondly, as we heard quite a bit yesterday, there's a strong emphasis in Pacem in Terris on the relationship between rights and duties. Now, as Mary Ann Glendon pointed out to us, that is present in the Universal Declaration of Human Rights. I might point out, the Universal Declaration of Human Rights was not the first international Declaration of Rights. It was preceded 6 months earlier by the American Declaration of Human Rights, which has an extensive list of duties. So the discourse was there, and to some extent was lost later, perhaps. But even to the extent that it's there, it's nothing like as rich and comprehensive as the emphasis on duties in Pacem in Terris. Pacem in Terris says, the natural rights of which we have so far been speaking are inextricably bound up with as many duties, both duties that inhere in the same person as the bearer of rights. For instance, the right to live involves the duty to preserve one's life, the right to a decent standard of living, the duty to live in a becoming fashion, the right to be free to seek out the truth, the duty to devote oneself to an ever deeper and wider search for it. It's also related to the reciprocal duties towards other persons, the rights of others. And with respect to both of these dimensions, the encyclical contains one of my favorite turns of phrase, where John the 23rd says, to claim one's rights and ignore one's duties, or only half fulfill them, is like building a house with one hand and tearing it down with the other. That phrase then points to a third important difference between these bodies of thought, and that is, what is the purpose of rights, or the end of rights? What is the teleology of rights, if you will? We've already said in our discussions that the rights in Pacem in Terris are viewed in the context of a variety of forms of order in human relations, as Russell Hittinger explained to us yesterday. But joined to the dignity of a human person as a being essentially oriented toward his or her eternal destiny, the telos of rights goes even further than mere order in society. It has a further end in Pacem in Terris. And it's illustrated in what I find to be one of the most remarkable paragraphs of the entire encyclical. So bear with me, I'll read it, even though it's a little bit long, in its entirety. Pacem in Terris says, when society is formed on the basis of rights and duties, men have an immediate grasp of spiritual and intellectual values and have no difficulty in understanding what is meant by truth, justice, charity, and freedom. They become, moreover, conscious of being members of such a society. And that is not all. Inspired by such principles, they attain to a better knowledge of the true God, a personal God transcending human nature. They recognize that their relationship with God forms the very foundation of their life, the interior life of the Spirit, and the life which they live in the society of their fellows. So what is the telos of rights here? The end of rights is nothing short of the unity and salvation of man, beatitude. Rights and duties are, one could say, a sort of preparatio evangelii, an anticipation of the gospel. The contrast is very clear. What is the end purpose, the teleology of human rights within secular discourse? Well, probably none, or at best, implicitly it is the protection of the person, but without reference to the ends of the person, without reference to any ultimate meaning and destiny of human life. That passage then, in turn, depends on a further and quite pervasive difference, the relationship between rights and truth. Persistently throughout the encyclical, John emphasizes the intimate relationship between truth and rights. The reason for rights is to recognize and protect the person's capacity to seek the truth in freedom, especially when read in conjunction with Dignitatis Humanae slightly later. That becomes even clearer. Before a society can be considered well-ordered, creative, and consonant with human dignity, it must be based on truth, John says. And even further, that truth is God. God is the first truth, the sovereign good, and as such the deepest source from which human society, if it is to be properly constituted, creative, and worthy of man's dignity, draws its genuine vitality. Thus again, a sharp contrast with the theoretical prioritization in liberal thought of the right over the good. Rights are not seen as a way to set aside or bracket an affirmation of the good here in Pacem and Terris. They're not untethered from truth. Finally, another way in which the good precedes rights in Pacem and Terris, and not vice versa, is that rights are understood to be integrated with one another as a coherent whole, as part of a common good, indeed a universal common good. Rights are nothing other than specific aspects of that common good, in a sense, and thus ripping them out of that context distorts them and does violence to the whole being the dignity and destiny of the human person and the harmonious order in relationships between them. Thus, as Mary Ann Glendon indicated yesterday, this is perhaps a contrast with the current practice of rights more than with the conception and articulation of rights at the time of Pacem and Terris. And truthfully, even today, the principles of the indivisibility of human rights and the interdependence of human rights are mantras repeated within human rights discourse. But already in 1963 versus 1948, in those two discourses, there is the seed of a certain important difference. In the Universal Declaration, the integrated nature of rights in a unified whole is, in some senses, implicit in the drafting of the document, especially in René David's redrafting of a document which was quite a bit more fragmented before he put his hand to it. In Pacem and Terris, though, instead, the whole supporting structure for discussing rights is one of unity and order and integration. So one can summarize many of these differences in the one of the sentences by which Pacem and Terris characterizes the importance and meaning of the Universal Declaration of Human Rights. It says, "The Universal Declaration is a solemn recognition of the personal dignity of every human being, an assertion of everyone's right to be free to seek out the truth, to follow moral principles, to discharge the duties imposed by justice, and to lead a fully human life." A rather different characterization of that same document than many in the secular world of human rights would give, certainly today. So that brings us then to the next question. Do these differences really matter? One of the basic premises of the human rights experiment in the mid-20th century was to craft a language and eventually a legal apparatus to affirm human dignity and advance global justice, even in the absence of a thick agreement over the foundations and principles behind it. It is, as we all know, an exercise in practical agreement, in overlapping consensus, that is deliberately intended to allow a multiplicity of divergent perspectives to reside within the capacious boundaries of the language of rights. Having agreed on basic principles of action, then does it make a difference that Pacem and Terris expresses an understanding of the source and end of the human person and of rights that is different from many other approaches that could be used to support a similar commitment to realizing human rights? John the 23rd, in fact, anticipates the very question, at least indirectly, and he gives a resoundingly clear answer: maybe. As we've already heard yesterday, the Pope separates the practical undertakings in history from whatever potentially erroneous philosophies may animate them. He says, it is perfectly legitimate to make a clear distinction between a false philosophy of the nature, origin, and purpose of men in the world, and that's on the one hand, and the economic, social, cultural, and political undertakings, even when such undertakings draw their origin and inspiration from that philosophy. He goes on, who can deny the possible existence of good and commendable elements in these undertakings? Elements which do indeed conform to the dictates of right reason and are an expression of man's lawful aspirations. It may sometimes happen, therefore, that meetings arranged for some practical end, one might think of a UN conference, right, may in fact be fruitful at the present time, or at least offer prospects of success. So from this and from the related passages around it, we can see that John the 23rd, at least, clearly endorses a Catholic engagement with the world of human rights, even if, and indeed in part precisely because of, the differences in underlying philosophies regarding the nature, origin, and purpose of men and the world. And very much historical experience validates this view. José Saliquet's work, together with the church in Chile, is a tangible historical example. The role that the Catholic Church has played throughout the world in the so-called third wave of democratization, and many other practical examples also exist. At the same time, however, John does subject that potential cooperation in practical historical undertakings to a test, to the test of prudence. As he puts it, whether or not the moment for such cooperation has arrived, or perhaps at a distance of 50 years, we could say whether it is still present, and the manner and degree of such cooperation in the attainment of economic, social, cultural, and political advantages, these are matters for prudence to decide. Prudence, the queen of all the virtues which rule the lives of men, both as individuals and in society. And what does prudence require? Again, as the encyclical bears witness in its very structure, prudence in this requires reading the signs of the times, and it does so, or seeks to do so, explicitly and deliberately over and over. The cooperation of past decades, therefore, today is not by itself sufficient reason for assuming that the same possibilities for cooperation exist today. One also has to be realistic and acknowledge that the two arcs of development of the two narratives of human rights that I've been exploring here have in some ways been growing further apart, not closer together, over the last 50 years. Although I certainly hope it's not true, objectively, I think there is at least some reason to fear that Pacem and Terris may have represented the apex of convergence, and that we are now on two orbits that are increasing the distance between the vision of Pacem and Terris and the mainstream human rights world. I don't have enough time to give you detailed examples, but at least here and in this last part, I'd like to suggest some of the principal ways in which the gaps between the two understandings are increasingly evident in theory and practice today, 50 years after Pacem and Terris, more than they were a half century ago. First and foremost is the cornerstone concept of human rights, human dignity. There's a massive literature and practice, juridical practice, relating to human dignity today, much more than there was 50 years ago. And yet, what does it evince for us? Nothing more than really the complete deconstruction of the concept as a whole. When you read the literature and the jurisprudence of dignity, it's clear that it has no stable meaning whatsoever, no commonly understood reference point. It means anything and everything, completely contradictory, even contradicting itself in the same judicial decision by the same judge. Secondly, I think relative to 50 years ago, we have lost at least a fair portion of whatever common understanding we might have had then of what the human person is that is the basis for the common action and coordination that we are collaborating in. On the one hand, we have increasingly a vision of the human person that is completely a self-constructed, self-realized entity. And secondly, one in which the spiritual dimensions that are so strongly emphasized in Pacem and Terris of human personhood have been reduced, a reduction of the person to the material. Thus, among the competing conceptions of dignity out there, one that is increasingly prevailing in much of the discourse is a version of dignity that radically exalts an individualistic form of human autonomy. I know, just anecdotally, even though it'll take an extra few seconds here, one of the honors that I have the privilege of following Jose Salaquet in is as a member of the Inter-American Commission on Human Rights. And when I became president of it and gave my inaugural speech as the president before the General Assembly, not the General Assembly, the Permanent Council of the Organization of American States, I made a reference to the desire of the people of the Americas for freedom. You would think it was an innocuous statement. I was taken aside afterwards to ask, why did you attack Cuba in your speech? So what do you mean I attacked Cuba? I didn't attack Cuba. You made a reference to freedom. Now, I say this not because of the humor of, the coded diplomatic language or because of Cuba versus the United States, but really because that was the revelation to me that the language of freedom has, in significant ways, disappeared from much of human rights discourse, right? There is instead a different form of emphasis on autonomy it's a very different conception of what's going on, and therefore the notion of freedom gets reduced merely to political terms. So a different sort of possible divergence and implication that is related to these first two is that with individualism, with an emphasis on autonomy, with a deconstruction of dignity, there's an increasing emphasis on the autonomous individual's rights over any kind of good or right that can be understood as having a collective dimension or a communal nature. On the one hand, we have an inflation of individual rights in a scheme in which every individual desire has the potential to become a human right. The desire for the assertion of one's personality becomes the human right to get a tattoo. I'm not making that up. Okay? The desire for parenthood becomes the right to genetically engineer a child. I'm not making that up. And at the same time, this inflation means a dilution of the meaning of certain rights, so that, for example, the right to be free from torture is now asserted to apply to any state restriction on access to abortion, meaning the expectant mother is being tortured by it. Right? So there's an increasing conflict in that dynamic between the assertions of rights of individuals and the communal dimensions of human personhood. You see those resulting increasingly in a conflict over freedom of religion, for example, which necessarily has to be understood as a collective and social practice. A third important difference from 50 years ago that might make the divergences matter is a different understanding of the importance and centrality and very nature of the family. It's not too strong to say it is, in fact, under attack now. With it, less so, but visibly, is a reduction of the scope for all sorts of intermediate institutions and communities. But the family in particular is one that I can say from experience in politics of human rights as well as in the theory is so disfavored as to be rejected entirely. A fourth difference related to the emphasis on duties in Pacem and Terris is, in fact, the absence of duties today, either in one's own personal life or in relationship with others. It's increasingly apparent. It's apparent in, for example, the formulations that lead to saying the right to life includes the right to destroy one's own life, or the right to life includes the right to destroy another's life, rather than saying responsibility, solidarity, and love are intimately related to the very meaning and purpose and ends of rights. Many of these differences and others that one could articulate, I find coalesce, as I've already begun to hint, around the question of freedom of religion. And it is this difference between the vision of Pacem and Terris, the centrality of the search for an ultimate truth that is inherent in the very structure of the human person, that is starkly different with contemporary human rights practice. On the one hand, freedom of religion is not just important to Pacem and Terris, but absolutely central. It's the cornerstone of a vision of human freedom and dignity. On the other hand, in the mainstream secular human rights community, it's increasingly being ignored or, worse, subordinated to whatever other right might be seen to be in tension with it. Let me conclude. I've gone even too long already. Does all of that mean, even if my diagnosis is correct, that prudence should lead us to abandon the hope for common ground on human rights today, in contrast to the hopeful vision of John the 23rd 50 years ago? While I'm sober about the possibilities, I think, and I hope, I believe that the answer still is no. No, we should not abandon the effort. In fact, on the contrary, my experience in the practice of human rights, as well as thinking through it, makes me even more convinced that we are in need of a greater Catholic presence in the field of human rights. And I can say institutionally at Notre Dame and at our Center for Civil and Human Rights, we're staking a very great deal on that proposition. It is not a small task. It's one that is risky, as was said yesterday about Pacem and Terris as a whole. It is a risky document in the way that it engages the world. This is a risky proposition. It's also a task that is, as John 23rd says in general, an immense one. But he reminds us that our task is not to engage in small steps, but immense ones. And yet, it's subject, I would think, to two caveats at least. And this is my conclusion. One, Pacem and Terris makes clear towards the end that this immense task is one that we have to be prepared to achieve little by little. There are some people, he says, who in their generosity of spirit burn with a desire to institute wholesale reforms whenever they come across situations which show scant regard for justice or are wholly out of keeping with its claims. They tackle the problem with such impetuosity that one would think they were embarking on some political revolution. We would remind such people, he says, that it is the law of nature that all things must be of gradual growth. If there is to be any improvement in human institutions, the work must be done slowly and deliberately from within. Now, the irony, of course, is that 50 years later, those words apply often to the human rights enterprise itself, and not merely to the application of the human rights enterprise to the rest of politics. The second and last caveat, which we take from Pacem and Terris, is that the prospects of that slow and deliberate change directly depend on increasing the presence of persons in the environment of human rights. Persons who bear with them a different sensibility, a different vision, who incarnate a different understanding of the human person. It is not sufficient to engage in an intellectual discourse. It's not sufficient to develop a doctrine. It is a human encounter that will make the difference over time. And I'll conclude with these last words, very beautiful, from John the 23rd. We are encouraged to hope that many more men and women, Christians especially, will join their cause, meaning the cause of those who are present in the world shouldering responsibility for justice. Everyone who has joined the ranks of Christ must be a glowing point of light in the world, a nucleus of love, a leaven of the whole mass. He will be so in proportion to his degree of spiritual union with God. Thank you.